Good afternoon. Good afternoon and welcome. As the Dean of the University of Denver's Sturm College of Law, it's a great privilege to welcome you all to the Ricketson Law Building, a LEED Gold building and in many estimations, one of the nation's finest. It is my job today, and a very good one, to introduce our distinguished keynote speaker, Camille Pannu. A graduate of the University of California, Berkeley, with distinction in political economy, and the UC Berkeley School of Law, Camille is director of the Water Justice Clinic at the University of California Davis College of Law, a project of the Aoki Center for Critical Race and Nation Studies. In that important leadership role, she leads a clinic that partners with stakeholders to improve the sustainability of rural water systems, to advocate for greater inclusion of rural and low-income communities in water management decisions, and to ensure that all citizens of the state of California have access to safe, clean, and affordable drinking water. After graduating from law school, she clerked for the Honorable Richard A. Pez of the United States Court of Appeals for the Ninth Circuit and the Honorable Stephen Underhill of the U.S. District Court for the District of Connecticut. She worked as well as an Equal Justice Works Fellow in the San Joaquin Valley. There, in an area brought to public attention in the 1940s by John Steinbeck's Grapes of Wrath, and now acutely challenged by air pollution, soil salination, and nitrate-contaminated water, she assisted low-income organizations, including low-income communities of color, with improving infrastructure and creating both worker and community-owned enterprises. A self-avowed hellraiser, she has a deep and enduring commitment to environmental justice. She was raised in Richmond, California, an economically depressed, multi-ethnic community in California's East Bay that has confronted over the years some very challenging environmental matters. In the early 1990s, a tanker car containing concentrated sulfuric acid overheated and exploded in Richmond, creating a poisonous gas cloud that was styled at the time a mini Bhopal. And Richmond remains home to the Chevron Richmond refinery, the largest industrial polluter in the Bay Area, and one that has been fined on multiple occasions for the release of toxic gases, including chlorine and sulfur trioxide. There could be no better person in this nation, and surely no more authentic one, to speak to issues of water governance through a racial and social justice lens than Camille. Before turning the podium to her, I want to offer some brief thanks and some brief closing reflections. First, thank you to our partners on the University of Denver campus, the Interdisciplinary Research Incubator for the Study of Inequality and the Center for Sustainability for collaborating on this event. Thanks, of course, to the student editors of our Denver Water Law Review for putting together this innovative and really incredible conference. And very special thanks to the Symposium editor of Volume 21, Lindsay Ratcliffe, a former student of mine, a graduate of the University of Colorado at Boulder, a graduate of the Yale School of Forestry and Environmental Studies, and in her own right, a staggeringly impressive student, but I also wish to say emblematic of the incredible students we recruit to this law school to study environmental and natural resources law and water law. Now to a final reflection, and it's not meant to be a political one. In recent years, it has become commonplace for practitioners and occasionally judges to poke fun at legal scholars, indeed to poke fun at the student law review editors who publish their work. In 2011, in a C-SPAN interview, Chief Justice Roberts criticized law professors and those student editors for publishing articles, quote, on the influence of Immanuel Kant on evidentiary approaches in 18th century Bulgaria, something Justice Roberts apparently thinks we do at schools like Denver Law. With due regard to him and the office he holds, he does not capture the spirit of this place or of this conference. The spirit of this place, of this law school, is not to reflect on arcane matters, but to deal with real-world issues, something we've been doing since 1904 when we started the nation's first law clinic. The spirit of this conference is not to spin ivory tower theories, but to explore pressing real-world issues. Here, how historically marginalized communities have owned, managed, and asserted rights over one of our most precious natural resources. And if I may, in the spirit of solemn and profound reflection, that was not the spirit of Fred Cheever, who did not think apart from the real world, but sought to advance our understanding in a way that would better this campus, to better this region, and to better the world that we share. Thank you for being with us and helping us advance those critical aspects of our history, our spirit, and our mission at the University of Denver's Law School. Thank you.
Thank you for that extremely generous introduction, and thank you to everyone who's here today. These students who've put together this symposium are truly impressive, and really this has been one of the best experiences I've ever had at a symposium, so thank you for putting this together and for putting in so much careful thought into how this day has come together. So I'd like to talk a little bit about human dignity for our address today. In particular, I'd like us to understand the central roles that race and poverty have played in this nation's history and in who has received access to water and who has not received access to water. I'm going to talk at you for some time, but I will create time for questions as well. If I go too quickly, if something seems confusing, feel free to look at me with a very blank stare. I'll slow down, and I'll try to reorient. Sound good? All right. Far be it from me to keep people from their food. Okay. So right now we're at a really unique moment in this country. We've begun to talk about the very practical racial effects of water inequality. It really hit national news when we talked about Flint, Michigan, but since then we've seen the Standing Rock Sioux really assert the essential and vital nature of access to safe water for Indian tribes. We've had a greater discussion about colonias in Texas's Rio Grande Valley and throughout the rural Southwest. There's been greater attention paid to Puerto Rico, which had historically poor infrastructure, which has now been decimated and destroyed by Hurricane Maria, and to this day, over half of the island still has no access to safe potable drinking water. And we've also begun to understand how all of these water policies and how our system of water management has created some of this vulnerability and inequality. And so part of what I'd like to do today is to kind of uncover or trouble our traditional discourse. So normally when I go to water policy or water law conferences, it's the same framework every time, right? It's a discussion about ag versus cities versus the environment and environmental protection. And what I'd like to talk about today, or what I'd like to trouble a little bit, is the human face that gets subsumed under that kind of master narrative of what is water law and what is water policy. And in particular, I'd like us to kind of understand the specific role that vulnerable communities, which are often communities of color, play. And I'm going to talk at length about rural communities in California because that's my stomping grounds. But I have a feeling that some of the things I'll talk about are going to echo or resonate with folks because there are many issues that kind of bind the Southwest and the American West in general when it comes to water and access. I also promise you, I practice in the deep red part of the state, so it's also, not the kind of traditional coastal view of what's happening with water. So I'd like to first start by framing water inequality and to assert that essentially water quality is a racial justice issue, not simply a poverty issue. I'm then going to talk a little bit about some of our clients and case studies and specifically what the Davis Law School Clinic does, and then I'm hoping to conclude with kind of a call to action for law students and water practitioners who've come here today. So to give you some context, the New York Times has recently reported that about 1/5 of all Americans lack access to safe drinking water. They're receiving water from a public water system that has failed some public health metric. And those public health metrics seem really wonky, but they're often really basic. It's things like lead, cadmium, nitrates, water pollutants that are extremely toxic and often carcinogenic or have other health effects that are immeasurable and devastating. In addition to the 1/5 of Americans who are receiving dirty water or unsafe water, another quarter don't receive any public water at all. So those are folks who are living off of rural wells. They're drinking completely untreated water, either through stream diversions or through groundwater that's been not treated in any way, shape, or form. That's kind of staggering. When I read those numbers, I was taken aback. That means half our country is water insecure. They have no access to safe water, or they're drinking water of dubious quality, and they don't know if it's killing them or not. And I find that kind of shocking in a country that's so affluent and that has so many resources and so much capacity and has invested so much in moving water. So the West is full of these massive water projects, and yet, the country as a whole has almost 45% of its population completely left out in the dark. In addition to the 45% who likely lack access to safe water and have to deal with those public health effects, 12% of U.S. households lack access to affordable water. And a recent study suggested that by 2022, 1 in 3 Americans will not be able to afford their water bills. And this has really devastating effects on people. So it's not just that you can't afford your water bill or that you have to buy replacement water and that it's extraordinarily expensive. You can literally lose your house or your children for failing to pay. So in 21 states, lack of access to safe water is considered a form of child neglect. So if you are part of a water system that serves unsafe water and you are not purchasing private water for your children, you can have your children taken away from you. And if you are in Flint, Michigan, or in other cities where your city has completely bungled how it's working out its water distribution system, the city can still require you to pay for water you're not using and can put a lien on your house and foreclose on it. And indeed, Flint, Michigan did that about a year ago and got in a great deal of trouble and finally said, okay, we won't put liens on your houses, we'll give you all a pass, but it wasn't a permanent policy, it was a one-time policy that came to light because of bad press in the national news media. So lack of access to water is not just about the very practical lack of access to an essential good and what I believe is an essential right for human existence. It also has tiering and cascading effects that can really destroy your life. And perhaps most surprisingly, at least 1 million households in the United States lack access to any form of plumbing at all. So these are folks who not only lack access to water, but also have no piping. And those plumbing deficits are most significant in rural Native American and Alaskan Native communities, and particularly on reservations. So when I think of water inequality, I think of it in 3 parts. And we can use different lenses for how we talk about it, but I think the 3 parts can be broadly grouped as lack of access to water, poor water quality, and then lack of supply. And access and supply are not always the same thing. Sometimes water's there, but you can't get access to it. In rural areas, in California at least, but also throughout most of the country, what we're seeing is a complete lack of access to public water systems and piped water. In cities, what we see is a high level of water quality problems. So those are like your lead contaminants and whatnot for the most part. In Indian country, what we see is particularly high levels of water contamination, and then that is made more significant and more vulnerable by fights over water rights and water supply. So we heard earlier today from the previous panel about the fight that's going on in the Coachella Valley over water between essentially a city, a reclamation district, and the Agua Caliente Band of Cahuilla Indians. And I can assure you that the entire state is watching this battle because it has huge implications in Indian country, but throughout California as well. In California, we have at least 1 million people who don't have access to safe drinking water. And we suspect that the number is actually probably 2 to 3 million, but the state does a bad job of counting people who are not on a public water system. So we don't really know how severe the water deficits are. But a recent study told us that of the people who live in the poorest and highest polluted communities in California, 50% of them are on wells. So I think it's safe to say that we're probably underestimating by around a factor of 2 to 3. That's roughly 10% of our state's population, which is kind of jarring. And drinking water inequality is the most severe in our agricultural belts, so in the deep red parts of the state where I work. So that's the middle of the state, it's parts of the Central Coast where we grow strawberries, and then it's also along the southern border where we grow dates and all sorts of other crops that are not indigenous to what we grow because we just move water and irrigate deserts instead. And in addition to that, the city neighborhoods where the majority of residents are likely to have unsafe water are almost exclusively neighborhoods with low-income people of color. So in California, Black folks in general are more likely to be exposed to lead, but Black children in cities with otherwise safe water systems are 3 times more likely to have lead from piped water in their blood, which makes no sense as far as I'm concerned. Latinos in our state are more likely to be exposed to nitrates. Nitrates are an agricultural pollutant that interfere with your body's ability to take up oxygen and cannot be boiled out of water. And they're also the most likely to lack access to water infrastructure at all. So they're highly unlikely to be on a public water system. And tribal water systems in the state are twice as likely as any other system to violate all health standards under the state's public health regime. Okay, so those are all my boring statistics. Everyone with me? Okay. So I want to talk to you a little bit. This is where we talk about human dignity. So I apologize because I wasn't able to bring community members with me. I would normally have them tell their own stories. I think it's much more powerful to hear from them. So I'll try to do them justice. And I'm going to tell you about a community called Matheny Tract. So Matheny Tract is a very small community. California uses the term rural to refer to any community that's not incorporated into a city, because we don't meet any of the other federal definitions of rural. And so they're right on the fringe of a city called the City of Tulare. And the City of Tulare has a long history of racial discrimination, and in particular it had laws that forbade people of color from living within city limits prior to the Civil Rights Movement. And so Matheny Tract was developed as a farm labor camp, essentially, and housing for farm laborers, but it ended up becoming a place of self-determination for Latino communities and for some low-income white folks who were coming through the Dust Bowl migration. And so Matheny Tract really became a location of, it's a location of high poverty, but it's also a community that's very interconnected, and it's a community that has exercised a lot of kind of coming together to make their systems work, to create water, to distribute water, to try to make everything work without the benefits of being able to be in the city and having elected representation. Matheny Tract is also in a county that's kind of infamous. It has the highest number of water violations in the state, has the highest number of failed systems. It's particularly rural in character. It has very few cities and is fairly broad and just like geographically vast. And so it's difficult to get people resources, but the county also had a formal policy of starving rural communities. So if you were a low-income community of color, they said, we're going to cut off all your money. We're not going to distribute any tax money back to you because we think you'll just die out over time. People will have to move. It's going to become too miserable. And of course, people who are very poor cannot just move, and they can't move into cities, which at the time cost 10 times more to live in than where they lived. And so what it did instead is it just compounded poverty and made it very dire and desperate. And they did that for about 40 years. They've actually only officially changed their policy as of 2010, and it was mostly because advocates publicized this provision in their original planning documents. So that makes it tough, but the other thing that makes it tough is that because the county is rural, they lack the money and the funding to now fix the problem that was somewhat created by their policies. Altogether, about 1,200 people live in Matheny Tract, and their most significant problem in terms of their water issues is that they have exceptionally high levels of arsenic. Their arsenic levels are over 100 times the state standard. It's about 10% by volume of their drinking water, which is insane. When I heard that, I was like, someone is like, just must have their measurements wrong. I was like, they can't be true. It's so bad that no one drinks it or cooks with it, and yet there's arsenic. Several community members have developed arsenic poisoning, having lived there for less than 10 years simply from showering in arsenic-laden water. So in addition to the fact that they have arsenic, which is extremely expensive to treat, the city of Tulare has decided that it wants to grow. But it doesn't want to annex in Matheny Tract. What it wants to do, because it doesn't want to pay for eminent domain, is it wants to site industrial uses all around Matheny Tract to make it so miserable to live there that no one will ever come out. So the first thing they did was they built a sewage treatment plant right next to this community, outside of city limits, but right next to this community. And they refused to run sewers to the community because they said that would encourage them to stay. So you've got a bunch of folks on septic right next to the treatment plant, which is ironic and humiliating for them. And then the city started to try to recruit heavy industrial manufacturing. So the air pollution would be through the roof. You're already in the most polluted air basin in the country. And in addition to that, they're surrounded by fields, so all the fields would disappear. They would all become massive, essentially like animal rendering plants, pesticide manufacturing plants, etc. And because they don't want to pay for it, the city's plan was over 20 to 30 years to cite these bad uses to drive down property values so that when finally people did want to leave, the city could afford to buy it instead of paying the fair market value that's there right now. So essentially what ends up happening is around 2006, the community starts getting very organized, and they have a really charismatic woman, I call her kind of the madrina, the godmother of the community, named Reina. And Reina is really amazing. Anyone who comes in, she tells them everything that's going on. All the parties and celebrations are in her backyard. She shows up at every city council meeting, every county meeting, every state hearing. She's at everything related to water in Matheny Tract. And so what the city ends up doing, or what ends up happening is California Rural Legal Assistance sued them. They sued the city for their land uses. That's our legal aid provider. And they won. And they sued multiple times. And so they ended up with a consent decree, so a negotiated settlement that the court signs off on. And the consent decree said that the city would extend sewer and drinking water service to Matheny Tract within 3 years. Then the city of Tulare received a significant amount of bond money, so free grant money from the state to build the distribution system. So they build the distribution system. We're now at this fight starts in 2006, now we're at about 2013, and they won't turn the water on. And they say, well, we're in a drought. California's in a drought, there's no water. We'll turn it on once we have it, but we can't jeopardize our water to our people in the city for your water. And here's what's awesome. They had water. They had water the whole time. What they were doing was they were illegally selling it to housing developers and new developments right outside of the city instead of connecting Matheny Tract. So they get caught. So the community, again, has to sue them to enforce the consent decree. At the same time, they then start filing planning documents. California has really arcane kind of land use provisions. So they're going to these technocratic land use agencies and essentially telling them oh, we don't want to build industrial things anymore. We're going to shrink. Just let us shrink our border because then we don't have to serve Matheny Tract. Then it would be illegal for us to serve them. Wouldn't be illegal. It's a specious legal argument. But that was kind of what they were going for, and they were hoping no one would catch that it would defeat the purpose of the consent decree. So thankfully the local agency, Reina, showed up, objected at the hearing, and the local agency said, you can't change your land use planning to defeat a court order. That doesn't work. That's not how this goes. And so when the community found out that they had been denied water, this was what Reina said, and I wanted to quote it because I think it's really meaningful. She says, and I'll translate afterwards, she says, parece que han visto acá como somos animales, como no fuéramos humanos. Primero nos dijeron que no había agua. Ahora aceptan que hay agua, pero mejor que dan a los contratistas que hacen nuevas casas. Y nos dejan acá siempre con el agua contaminada. So what that means in English is they treat us as if we were animals, as if we were not human. First they tell us there's no water. Now they admit that there's water, but they've decided it's better to give that water to contractors who are building new housing developments. And they leave us here, always, with contaminated water. And the reason I share Reina's quote is because that's what we're talking about when we're talking about water inequality. One day I'll be able to articulate this, but I can't adequately express the violence that is done to people when they are denied access to safe water and when they are treated with such horrific racism and just kind of contempt for their poverty, but it's wrapped up in the neutral language of, city management, or it's budgetarily not great. I mean, this was a community who had everything paid for by the state, and you have a city that's so intransigent, or so intransigent rather, that it would rather deny people water so that it could do something completely illegal in a moment and a period where not only did these folks not only had arsenic water, their other well went dry, and the city knew. And so the city knew that everyone was going dry with water, and they did this anyway. And the thing that is difficult to convey is that there are hundreds of communities like Matheny Tract in California, hundreds of them. We've only found 300 so far. I suspect there's many more that are hiding that we haven't found yet. And they've dealt with these issues for years and years and years. No one's really heard them or seen them. And it's horrific. It's a nightmare. But something happened in California that has changed how we deal with these communities, and I think that that's exciting. So I want to tell you about the good things that are happening too, because I don't want to just leave everyone feeling disempowered. So California has done a couple of weird things during the drought. We're way far behind Colorado when it comes to how we deal with groundwater and water in general. Colorado's far ahead of us on that. But we adopted a human right to water. Not enforceable, it doesn't give you a right of action, but it's now the adopted state policy. And we also, during the drought, authorized special funding for these communities that are particularly rural and low income and that lack access to safe infrastructure. So we had infrastructure and planning set-asides. They weren't enough, but it was a good start, and it was the first time it had happened in years and years and years. California kind of first began to think about these communities in 2006, and the drought created an opportunity for lawmakers to see how different communities were being affected, because for the most part the coast is not very aware of where their water comes from. They don't have any water. It all comes from the Sierra Nevada mountains, and so but when you turn on your tap, your water's there. So if your water's safe, you don't really think about the fact that there's millions of Californians without safe water. So those things combined with a kind of sneaky bill that got approved as a budget rider that gave the State Water Board the authority to mandate consolidations, which are forced mergers of water systems. And so what they did was they said if there's a low-income community in a water system that's providing unhealthy water, it's chronically out of compliance, and we can find a nearby safe water system, we can order merger, and we'll pay for it. We'll pay your infrastructure, you just have to figure out your taxes, you just have to figure out your water rates. But we'll take away the kind of heavy lift that comes from the infrastructure investment because California, much like Colorado, has a bunch of tax laws that make it very difficult to fund infrastructure unless you kind of get kind of insane thresholds and build a lot of dams. So what ended up happening in Matheny Tract was that the state finally ordered a consolidation. They've never used their mandatory authority to do that, and this was the first and only time in the history of the state so far that they've ever used that bill, was to make Matheny Tract, to force the city to abide by its consent decree and provide water to Matheny Tract. And so as of December 2016, the community's getting safe water, which is pretty remarkable. We're hoping sewers are on the way in the next 2 years. We have money for that too. And I think the thing that's really interesting is if we look at these communities, they share kind of common characteristics. So most of them were either labor camps or they were created as communities of self-determination. So California has freedom colonies. I don't know if folks are familiar with, no? Freedom colonies are most prevalent in Texas, actually, but the first freedom colony founded west of the Mississippi was founded in California. And they were communities of all black freemen, essentially, and former slaves who, after the Civil War, wanted to create safe communities to kind of, not so much, I mean, you've got the KKK riding around, you've got a lot of kind of backlash, so these were supposed to be safe communities for people to be able to farm, to have jobs, and to just have, a community that was self-sufficient and was not going to be in peril under Jim Crow. And so these freedom communities they exist all throughout the South. There's quite a few in Texas, there's one in California. So in addition to that, California has we call them colonias, but we're not allowed to use that term anymore because it means something else under federal law. But we have a lot of colonias that are similar. We have these communities of self-determination. They were originally created by communities who were racially excluded from cities, but they became places of self-determination and struggle. And so they became amazing. So there's one colonia, the Shafter Colonia, whose water was so clean that they used to sell it to the city. Like if you went there, it was kept so much more nicely than the city was kept, and they had all these amenities, and it was mostly because they had invested their labor into building their community in a particular way. And then the city cited a pesticide plant, and now we have a Superfund plant that contaminated their water supply. So there's always been kind of these pushes back and forth, and the other communities of self-determination that we often see are Asian communities. And so we have several, for example, Chinese American and Japanese American and Hmong American communities that were founded back in the Chinese and Japanese communities were founded back in the 1800s as kind of areas of self-determination. And so you have farming colonies all throughout California that kind of focus on that as well. They were all excluded from access to education and economic opportunity, and they were all intentionally deprived of funding. Might be shocking to hear this. California has counties that are on the pre-clearance list for the Voting Rights Act. pre-clearance list has been stricken, but we have a long and ugly history of racial segregation, including in quote-unquote progressive parts of the state. And so that legacy of exclusion is now paying dividends. It comes back. It doesn't ever go away. It just gets worse and worse, and now we have to, the bill has come due. But I think one of the things that's so fascinating about this, so Matheny Tract was a good example. In the San Joaquin Valley, what we found was exclusionary racial annexation. There's the term for it in academia is municipal underbounding, but that sounds very boring. Basically, it's racially exclusionary annexation. So it's that you pick communities that are white to annex into the city, and you purposely don't annex in similarly situated communities of color, to the point where there was a lawsuit over this, and they ended up settling. And that lawsuit that was brought against the city of Modesto was brought in 1999 and settled in 2007. So it's recent as well. It's not kind of old-time historic racism. But what we found was that cities were engaging in this strategic annexation in order to dilute the Latino vote in most places. So they wanted to dilute the vote both in county elections and to dilute it in city elections. And what they would do is they would do at-large elections and maintain a white majority so that you could never have Latino representation. One of our counties, Kern County, actually just lost a voting rights case on this, saying that they had unlawfully diluted the Latino vote in how they apportioned out their county supervisor seats. And if you're in a rural area, the county supervisor is who matters to you. So all of that is important to know, because I think that we sometimes don't realize the deep extent to which land use laws, local government laws, and water coalesce, and the ways in which water funding and water prioritization essentially reify inequality in a lot of ways. And so I think one of the things that's important as water practitioners is to understand that a social justice lens is necessary in order to fully understand the history of what we've done. The only way that you can kind of come to the conclusion that there's no inequality in how water is doled out is if you look at it completely ahistorically, and if it's okay with you that money should control who gets water. And those are two value statements that I think we all have to kind of ask ourselves if we agree with, because they're taken for granted and we assume that that's the way it is. And that's kind of how our water system has been built in the West. And I think there's a lot of movement there, and there's a lot of potential for us to think a little bit more about, well, what did we build? And did we build what we built then? Is it serving the goals that we have now? I would submit that in a lot of parts of the West, it's not serving any kind of equity goals whatsoever. But a lot of the change in California was possible because of community advocacy, and I think that's really essential as well. So it's not lawyers who won the day. It was community advocates who won the day, who lobbied, who went to the Capitol, who did press conferences. They were active for over 12 years before they were even made it into the newspaper. And they had been active 30 years before that, and many of them had been active in the farm workers movement. So these are folks who have the least resources, and they're investing the most in making structural change. What helped them was that once they had lawyers, they had people who could help them figure out how to change these systemic problems. So it wasn't just litigation, they changed the law. And that was really powerful for them, and has made it easier for us. So what we have now is we get all these set-asides in this big bond package, and there was all this funding, but none of the communities could access it. And so that was really frustrating, because we had $260 million just sitting there that no one could access. And what we found was that the state did a couple things that made it really hard to access. So the first is that they put their application exclusively online. And they thought that that was going to be very accessible, but it's not accessible in rural California where there's no internet. Most of our communities don't have broadband still. You can't fill out the application on your phone. So people weren't able to even submit applications for this money. The second thing that they kind of missed is that you have to have a qualifying recipient to get the money. So the money can't go to private well owners, for example, to bring them onto the well system. The counties and cities refuse to be the managers of the money in some of these areas. There are counties that do this well, I should say. They just are mostly not in the San Joaquin Valley. They're in other parts of the state. So there's Lake County, for example, is a very low-income county further north in the state. And they're phenomenal. They're the best county I've ever worked with. They get it, and they've been amazing, and they manage. They are willing to provide financial oversight. But in other areas, folks weren't. So what was making it difficult was the state said, okay, in order for us to give you money, you have to be able to prove to us that you have good managers and staff, that you have financial oversight, and that you have the ability to pay for your system after we make the improvements. These are all normal and, like, I think valuable criteria to have, but if these communities had any of those things, then they wouldn't need money. So the role that the clinic has been playing is essentially we're primarily a transactional clinic that is connecting people to money. So a lot of what we're doing is helping communities form water cooperatives, training them to have the managerial capacity to work on this sort of stuff. We've been developing trainings in Spanish and English for communities so that they can have more control over their local water boards and so that they know what questions to ask when water is being doled out. We're helping them enter into contracts and new partnerships with groups that normally don't work together. So we have a couple of irrigation districts in particular who have been interested in partnering with drinking water districts to create some redundancy in the system and to kind of balance out stream flows. Also to possibly help them dilute the number of contaminants in their water, which is not a great solution, but not a terrible solution. It's better than drinking 10% arsenic in your water. And as far as we know, we are the first clinic of our kind in the nation. So I get to feel pretty proud about that and excited. If I'm wrong, please tell me, because I've been telling people that and it would be embarrassing to be wrong. All our clients have to meet certain poverty definitions that the state has. So we only work exclusively in low-income communities and with low-income communities. We partner primarily with nonprofit institutions or with community groups that are not necessarily like incorporated as nonprofits, but they're resident groups that have been active. And our geographic scope is the entire state. So right now we have clients, including tribes at the northern border, all the way down to Los Angeles. We would take clients further south from Los Angeles, but a lot of those water systems are adjudicated and run by a couple of big interests. And so for the most part, they haven't wanted us there or needed us there. And we focus on kind of 3 areas of water law that are underserved in legal services in California. So as I mentioned before, there's a great deal of litigation, but there's not as much transactional law. There's not a lot of policy advocacy, and there's not a lot of strategic research. So that's where the clinic focuses its resources. In the first semester, our students are primarily being trained to be community lawyers, which is kind of weird. So it's like, how do you take business law and what you know about environmental law and put it together to deliver competent legal services to folks who come from a different political context than you, might come from a different ethnic or racial community, might be experts in their field and know a lot more than you, and you have to like kind of sit back and listen a little bit. And in the second semester, they're required to do a movement building project. So that's something that furthers water justice in the state in general, and so that has to be systemic or structural in nature. It can be strategic research, it can be doing policy advocacy with an organization and offering testimony or research or bill language. It can also include identifying policies that might need to change. And in some cases, they do media advocacy, and we do quite a bit of administrative advocacy at the state and local government levels. I'm not sure that we've got it all figured out. I don't know that we have, but we're trying very hard to not only serve the immediate problem on the ground and take care of it, but to also figure out how to help the state move to a place where it can think more strategically and holistically about how it ended up in this situation and how it's going to deal with the challenges coming down the pipe, including climate change. So, all right, I'm almost done. So my charge for students is going to be this, and for water practitioners. So the practice of environmental justice law is distinct from the practice of environmental law. And the key distinction is the role that the lawyer plays and the lawyer's relationship to a community. And so the way that I normally kind of frame this is that you can either be the lock that keeps people from accessing something, or you can be the key that gives them access to the new thing. In either situation, the client should be in control, right? If you're a key, you're a tool that a community gets to use in order to increase their self-determination, their power, their ability to kind of have a say over their own future. And we don't talk about this a lot in water law or in environmental law, but there are ways of doing this that can blend principles of direct legal services and community lawyering with traditional environmental law practice. And so what we saw in the clinic, for example, is that for the most part, in legal services, very few attorneys are trained in environmental law. Like, you don't see a lot of environmental lawyers kind of at legal aid. And very few transactional attorneys understand the kind of unique institutional capacity problems that exist for a lot of these under-resourced communities. And very few lawyers, and like then when you take them both and you put them together, there's almost no lawyers who understand both water law and water kind of regulations, and also how nonprofit law and cooperative law and business law works. And so what we're trying to do in particular is essentially increase just the capacity of lawyers in the state. And like if my students go to law firms, I'm perfectly happy with them. I want them to do a pro bono practice in this area because they can. And so I think a lot of what we're trying to do is essentially shift how the state looks at water practice. And so I think, of all the places I could think of forward-thinking, amazing, creative water lawyers, is certainly here in Denver and certainly in Colorado. And so I hope that that's something that you all take with you as you go out in the field. Even if you decide that water justice is not your thing, I hope that you'll realize or be aware of or think about dedicating some resources, either in your time or in how you spend your legal practice, essentially, trying to tackle these big picture issues that really go to kind of fundamental questions about who we are as a country and how we treat one another and what it means to belong in our states and in our nation. So that's all I have for you for now, but thank you so much, and thank you for having me. And I'm happy to take questions. I have 5 minutes because I talked for too long. No? Okay. Well, sorry.
Many people feel that water is greatly undervalued, therefore is misused. On the other hand, we have legitimate concern about poor people and the ability to pay. How do you feel about addressing that sort of conundrum?
Yeah, should I repeat the question? It was that many people feel that water is undervalued and that people don't pay for the true cost of water, but on the other hand, we have this issue of water affordability and access for low-income people. So how do we balance the two? So I'm not sure I have a great answer for you, except to say that our state's going through this process right now. We're doing a rulemaking related to a bill that was passed around water affordability. And what we're thinking of doing is essentially creating something very similar to what they do with like heating oil and electricity, which is to create a lifeline rate. So it's to have everyone in the state pay an extra $1. If you're low income, it would be waived on your bill every month, and then that funding would go into a pot that then goes out with our regular social services. So it would be paid out the same way like your food stamps are paid out to these low-income communities to pay their water bills. One of the big challenges I've seen, at least, is that I represent communities where the entire community is low income. If no one's paying their water bill, the water system's going to go under. So the state's trying to figure out how to channel money to those systems. First, what they're looking at is, frankly, how to consolidate those systems. I think that's the state's primary preference, is to get small systems to join up together, which I think they might be able to do. We just had a study that came out that showed that like 87% of failing systems are within like 3 miles of a compliant system in parts of California. So I think so that's one of the ways to get affordability. You make the pool of ratepayers bigger, right? You get an economy of scale that brings down prices for everyone. But the second is we're exploring a lifeline program, and it's going to be interesting to see how it works. But I agree with you, it's a tension. I mean, even if we do that, no one's paying for the cost of water in California. Everyone's paying for the cost of transporting that water, getting it to you. And I suspect that's the case in most states, from what I can tell.
Is there any talk about reducing pesticide and nitrate use in general?
I wish. There have been advocates that have been talking about decreasing agricultural pollution for a really long time. The state agency that regulates pesticides is not on board, and I think that makes it really, really difficult. We have a similar problem with fracking, to be honest. The state agency that's in charge of regulating oil and gas doesn't. They were, they were under a compliance order under the federal government from the last administration because they hadn't been looking at permits. They were just permitting like injection into all sorts of freshwater resources. The state is considering taxing nitrates and fertilizers at a slightly higher rate to then pay for water remediation on the other side, but I don't see any regulations about nitrate use coming down the pipe soon. They have tightened up their nitrate their nitrate standards. They're stricter than the federal government, but not by very much. And then we have listed pesticides that the feds have not listed, but it's difficult to police when we put the county ag commissioners in charge of policing it, and they often are not interested in regulating pesticide use. Okay, well, come find me anytime if you like. Thank you so much for having me, and please enjoy the rest of your day.